Hey everybody, and welcome back to my video blog. This week I have a very special guest, attorney Arielle Cecala with Crowley and Cummings. She is our go-to attorney, and she's going to talk to you today about the different ways you can take ownership when you purchase real estate. Stay tuned. All right, welcome back. So I'm very proud to introduce you all to a very good friend of mine, long-standing business partner, attorney Arielle Cecala with Crowley and Cummings. She handles basically every single transaction that our clients go through, and we trust her implicitly, not only on a personal level, but with obviously all of our business. So thank you, Arielle, for joining us. Just give us a little background on how you got here and how you're into real estate law.
Thanks, Josh. I'm really happy to be here with you guys today. So I am a real estate attorney. I also have a focus in wills and trusts. I've been doing this for 13 years, and I really love the people aspect of real estate law. So it's a fast-moving business, and I think that we're able to bring a lot of support and help to our clients going through a very stressful process, what can be a stressful process of buying and selling real estate.
Yeah, that it is, as we both know. So one of the questions that I get the most, Arielle, and I wanted to bring you on today to talk about this, is people ask, how should I take ownership of the property? I've either purchased a property or I've looked into it, and people ask me, well, what way do you want to do this when they're speaking to their legal counsel? And so I wanted you to just kind of shed some light on what are the two options, at least that I know about, as ways of people taking ownership.
Absolutely. So this is extremely important when you're dealing with two people who are taking title together. So the options are, you can take title as tenants in common, or you can take title as joint tenants. So the distinction between the two of these is very important, actually. And this distinction is noted on the deed. So when the clients take title, it's listed John and Mary Smith as, and then we state the tenancy. So with a tenant in common, this means that if one of the owners passes away, that their interest actually goes through the probate process, and the beneficiaries of that interest are the heirs of the person who's passed away, their heirs at law, or the people that they've named in their will. So that could leave somebody a different type of family ownership along with the survivor of the tenants in common. It's important to note that if you do not state tenancy on a deed, that you automatically default to being tenants in common. So people can actually have this happen by accident, which is often not the intention. The other form of ownership that's very common is a joint tenancy, or you might hear the term joint with the right of survivorship. And what this means is that when one owner passes away, the other owner becomes the owner of the property entirely, and there is no probate estate or anything that has to do with the owner who's passed away. So people really like this form of ownership because it streamlines things and means that the joint owner doesn't have to jump through any hoops or file any probate or take any other action, really, because at the moment of the death of the first owner, the property is entirely vested in the survivor.
Okay, so I guess the way it's described, how you just explained it, is, for example, if I'm buying a property with my brother and we're tenants in common, and I pass away, whoever's named in my will, for example, my children, would take over my piece of ownership in that situation. Whereas in joint tenants, if my brother and I own a piece of property and I pass, he would then have the total ownership of the property.
That's exactly right.
Excellent. All right, well,
and so,
let me ask you another question, if you don't mind.
Sure.
In regards to, we see a lot of people buying houses that are significant others, but maybe not married. So this is obviously what you just explained really applies to that situation. I guess I have two questions. Number one, if you're an individual, I assume that you only take the ownership as an individual. And
That's right.
What happens if you're married? Is there a different kind of ownership where you're legally married, and is there a different name for it and different rules around it?
That's a great question. So it's important to do the analysis and to talk to your attorney when you're doing the analysis. If you're in the significant other situation where you're not married and you might have different heirs, maybe you have kids from a prior marriage or something like that. So it's important to have the conversation with your attorney about the implications of these types of ownership, and then really what fits you the best. If you are a married couple, that is what we call in Massachusetts tenants by the entirety. And that works the same way that a joint owner with the right of survivorship works. So when you take title as husband and wife by tenants by the entirety, if husband passes away, wife owns the property outright. And you do want to use the words tenants by the entirety, and also to indicate that husband and wife are married to each other, or of course, husband and husband, wife and wife, that the couple is married to each other so that they can get the tenants by the entirety designation.
Okay, excellent. This is just as simple as you're making it sound. It's very, very important that you have the conversations with your legal counsel, as you said, because these are very different ways as property will transfer in given the situation if somebody passes on or whatever the case may be, which, as you know and I know, happens frequently. So it's very, very important stuff that we're talking about. And the question does come up all the time. So it was great for you to give that breakdown. I'd also like, if you're willing to, next month, I'd love to have you back as a guest again to talk about the different types of entities that you can create, legal entities outside of just taking ownership as a person, as a legal entity, and what some of those differences are. And we'd love to kind of get in a little bit deeper on our next interview, if that's okay. Absolutely,
that sounds great. Yeah, you can take title as an individual, as a couple, as a partnership, and then, as you noted, many other forms of legal ownership like trusts, LLCs, corporations. So we can do a little bit of a deeper dive into that next month.
Awesome. I can't thank you enough for coming on and spending a little bit of time with us today. More importantly, thank you for our relationship. You are just a great person and a fantastic attorney. And as many of my friends who may be watching this video know, that you're my personal counselor for all things real estate and estate planning. So thank you for all that you do, and thank you for being here today.
Well, it is truly an honor and a privilege to be a friend and a business partner. Thank you so much, Josh.
Well, thank you again, Arielle. As many people know watching, Arielle is a great friend and someone that we do a lot of business with, and she is my personal attorney for all things real estate and our estate planning. So if you have any questions on any of the content that she discussed today or that came up, please let me know. I can connect you to attorney Cecala directly, and she can have an offline conversation with you. Also, and when we come back in a couple weeks, we're going to get into deeper, as we talked about, different ways of owning real estate and different types of ownership that you'll have. So there's a lot of information that you can digest. But thank you again for watching. We hope that you join us next time on Josh Lioce's video blog. Have a great day.